Welcome back to Constitutional Corner. This is episode 3. In the previous 2 episodes, we talked about Marbury versus Madison. Marbury versus Madison and how it relates to judicial review. Now, naturally, there is limitations. And that's what chapter 2 discusses. Now, I kind of flipped through the book before I started recording. It's quite hefty. There's a lot here. Let's see. So we're not going to get through all of it today. It's going to be one of those multi-parts because there's starts at page 29 and it ends at 92. I'm not reading 50 pages tonight. I might read about 10. And we'll do this in sections. But yeah, let's begin. Chapter 2, Limitations on Judicial Power and Review. Section 1, Congressional Limitations. The current statutory jurisdiction is under United States Code Title 28. Let me repeat that. That is USC, so that's United States Code, USC, Title 28, Section 1251. And that title of that section is Original Jurisdiction. And then it goes on to say, A, the Supreme Court shall have original and exclusive jurisdiction of 1, all controversies between 2 or more states, 2, all actions or proceedings against ambassadors or other public ministers of foreign states or their domestics or domestic servants, not inconsistent with the law of nations. This B, and then it goes on to B, the Supreme Court shall have original but not exclusive jurisdiction of 1, all actions or proceedings brought by ambassadors or other public ministers of foreign states or to which consuls or vice consuls of foreign states are parties. 2, all controversies between the United States and a state. 3, all actions or proceedings by a state against the citizens of another state or against aliens. Then it goes on to say Section 1254, Courts of Appeals, certiorari, appeal, certified questions, cases, and it goes on to say cases in the Courts of Appeal may be reviewed by the Supreme Court by the following methods. 1, by writ of certiorari, granted upon the petition of any party to any civil or criminal case before or after rendition of judgment or decree. 2, by appeal by a party relying on a state statute held by a court of appeals to be invalid as repugnant to the Constitution, treaties, or laws of the United States. But such appeal shall preclude review by writ of certiorari, that's a weird word, at the instance of such appellant. And the review on appeal shall be restricted to the federal questions presented. 3, by certification at any time by a court of appeals of any question of law in any civil or criminal case as to which instructions are desired, and upon such certification the Supreme Court may give binding instructions or require the entire record to be sent up for decision of the entire matter in controversy. And then it goes on to say Section 1257, State Courts, appeal certiorari, final judgments or decrees rendered by the highest court of a state in which a decision could be had may be reviewed by the Supreme Court as follows. 1, by appeal, where is drawn in question the validity of a treaty or statute of the United States, and the decision is against its validity. By appeal, where it is drawn in question the validity of a statute of any state on the ground of it being repugnant to the, basically being against the United States Constitution, treaties, or laws of the United States, and the decision is in favor of its validity. And that basically means it's a question of whether or not whatever they're reviewing is against the Constitution or laws of the United States or treaties that we're bound by. And then it goes on to say 3, by writ of certiorari, where the validity of a treaty or statute of the United States is drawn in question, or where the validity of a state statute is drawn in question on the ground of it being repugnant to the Constitution, treaties, or laws of the United States, or where any title, right, privilege, or immunity is especially set up or claimed under the Constitution, treaties, or statutes of, or commission held, or authority exercised under the United States. That is law. That is law. That is congressional law that was enacted into the United States Code. Okay. Now we go on to, and that's what they say about the limitations on power, right? So the Supreme Court basically has original jurisdiction in all matters pertaining to the Constitution, pertaining to federal law, that sort of thing. If it's an appellate, of course, is state decisions and such. So, but that's not the focus of this channel. The focus of this channel is obviously constitutional. So, we'll continue with this discussion. So, in 1869, there was a court case that went before the Supreme Court. It was Ex parte McCardle. And the actual when I say the following, it's basically like the court case, like the official Supreme Court docket, and then you can type in this number and you will find the actual opinion. It is 74 U.S. parentheses 7 wall 506 19 LED 264, of course, the year 1869. So, here we go. Congress, on February 5th, 1867, had empowered federal district courts to grant writs of habeas corpus to persons restrained in violation of the Constitution, treaty, or federal law. Appeal could be taken to the circuit court and thence to the Supreme Court. McCardle, imprisoned by the military government of Mississippi pursuant to the Reconstruction Acts for publishing incendiary and libelous articles, allegedly unlawfully restrained by military force, sought habeas corpus, which was denied. He appealed to the Supreme Court, and after argument, but before decision, Congress passed the following act. That so much of the act approved February 5th, 1867, as authorized as an appeal from the judgment of the Circuit Court of the Supreme Court of the United States, or exercise of any such jurisdiction by said Supreme Court on appeals which have been or may have been taken, may be taken, be and same is hereby repealed. Argument was now heard upon the effect of the repealing act. The Chief Justice Chase delivered the opinion in the court. It is quite true that the appellate jurisdiction of this court is not derived from the acts of Congress. It is, strictly speaking, conferred by the Constitution. But it is conferred with such exceptions and under such regulations as Congress shall make. It is unnecessary to consider whether, if Congress had made no exceptions and no regulations, this court might not have exercised general appellate jurisdiction under rules prescribed by itself. From among the earliest acts of the first Congress was the Act of September 24, 1789, to establish the judicial courts of the United States. That act provided the organization of this court and prescribed regulations for the exercise of its jurisdiction. The source of that jurisdiction and the limitations of it by the Constitution and by statute have been on several occasions subjects of consideration here. In the cases of DeRosu versus United States, 6 Cranch 307, particularly, the whole matter was carefully examined, and the court held that while the appellate powers of the court are not given by the Judicial Act, but are given by the Constitution, they are nevertheless limited and regulated by that act, and by such other acts as have been passed on the subject. The court said, further, that the Judicial Act was an exercise of the power given by the Constitution to Congress, quote, of making exceptions to the appellate jurisdiction of the Supreme Court, end quote. They have described affirmatively, said the court, its jurisdiction said And this affirmative description has been understood to imply a negation of the exercise of such appellate power, as it is not comprehended within it. The principle having been thus established, it was an almost necessary consequence that acts of Congress, providing for the exercise of jurisdiction, should come to be spoken of as acts granting jurisdiction, and not as acts, ACTS, making, not like acts, like I'm going to axe you to death, like an act. Someone performed an action. So many words. Making exceptions to the constitutional grant of it. The exception to appellate jurisdiction in the case before us, however, is not an inference from the affirmation of other appellate jurisdiction. It is made in terms. We are not at liberty to inquire into the motives of the legislature. We can only examine into its power under the Constitution, and the power to make exceptions to the appellate jurisdiction of this court is given by express words. What, then, is the effect of the repealing act upon the case before us? Without jurisdiction, the court cannot proceed at all in any cause. Jurisdiction is power to declare the law, and when it ceases to exist, the only function remaining to the court is that of announcing the fact and dismissing the cause. And this is not less clear upon authority than upon principle. Judicial duty is not less filthy. It must be filthy. It says filthy. Performed by declining ungranted jurisdiction. It must be It must be not less filthy, because there's, yeah. It's spelled F-I-T-L-Y. It's Old English. No, it's filthy. It's supposed to be filthy. Filthy performed, not less filthy performed, by declining ungranted jurisdiction than in exercising firmly that which the Constitution and the laws confer. Counsel seems to have supposed, if effect be given to the repealing act in question, that the whole appellate power of the court in cases of habeas corpus is denied. But this is an error. The Act of 1868 does not accept from the jurisdiction in any cases but appeals from the circuit courts under the Act of 1867. It does not affect the jurisdiction which was previously exercised. The appeal must be dismissed for want of jurisdiction. And it goes on to notes and questions. Number 1, the extent of the decision. In ex part Yerger, 75 U.S. 8 Wall 8519, also challenging the Reconstruction Acts, the court, upholding its appellate jurisdiction by writ of certiorari in a habeas corpus proceeding based on pre-1867 legislation, said of McArdle, the effect of the act was to oust the court of its jurisdiction of the particular case then before on appeal. And it is not to be doubted that such was in effect intended, nor will it be questioned that legislation of this character is unusual and hardly to be justified except upon some imperious public exigency. More recently, Justice Douglas, joined by Justice Black, stated, quote, there is a serious question whether the McArdle case could command a majority view today. In Glidden Covey Zedonk 370 U.S. 350, blah, blah, blah. And then it goes on B. How great an incursion into the court's jurisdiction did McArdle in effect permit? Consider Ratner, congressional power over the appellate jurisdiction. The statute did not deprive the court of jurisdiction to decide McArdle's case. He could still petition the court for an original writ of habeas corpus. The legislation did no more than eliminate one procedure for the Supreme Court review of decisions, denying habeas corpus while leaving another equally efficacious one available. C. Does McArdle stand for the position that Congress may completely deprive the court of power to review certain federal questions? Apart from McArdle, does Congress have this power? The power to deprive the court of all appellate jurisdiction? If not, what is the meaning of the exceptions language in Article 3? It is, quote, that Congress may accept certain cases otherwise subject only to the court's appellate jurisdiction by adding them to the court's original jurisdiction. Van Alstyne, a critical guide to Marbury versus Madison. 1969. It is the Constitution itself only grants appellate jurisdiction in all other cases before mentioned, and that Congress may make exceptions to this by adding to the appellate jurisdiction cases that Constitution has assigned to the original jurisdiction. For the position that this clause was intended to permit congressional control over the court's appellate jurisdiction only as to the questions of fact, not questions of law. See Mary Scope of the Supreme Court's appellate jurisdiction, historical basis. Let's see. See also, it's got a bunch of cases. And it goes on to say, consider Ratner at Supra at one. The Supra means like at page 171 to 172. Quote, it is reasonable to conclude that the Constitutional Convention gave Congress authority to specify orderly procedures and to modify the jurisdiction from time to time in response to prevailing social and political requirements within the limits imposed by the court's essential constitutional role. It is not reasonable to conclude that the Convention gave Congress the power to destroy that role. Reasonably interpreted, the clause means with such exceptions and under such regulations as Congress may make, not inconsistent with the essential functions of the Supreme Court under this Constitution. 2. Congressional proposals to limit the court's appellate jurisdiction. Consider Auerbach, Garrisonhurst, and Merriman, The Legal Process, 673 to 77 in 1961. During the first session of the 85th Congress, Senator Jenner introduced a bill, S-2646, to deprive the Supreme Court of appellate jurisdiction in cases questioning the validity of 1. Congressional investigating committee proceedings, 2. Any federal loyalty security program, 3. State programs to control subversive activities within the state, 4. Public or private school programs to control subversive activities by teachers, and 5. State regulation of the admission of the persons to the practice of law within the state. If the appellate jurisdiction were taken away in these cases, the state and federal courts by themselves would be unable to achieve a uniform interpretation of the constitutional provisions applicable in these cases. An individual's rights would then depend upon the irrelevant circumstance of where he happened to bring his case, an outcome which violates fundamental notions of equal justice. Furthermore, passage of a bill like S-2646 would constitute a thinly veiled threat to the lower federal courts to disregard the Supreme Court's prior decisions in the 5 categories of cases in question. Even if the lower federal judges were determined to resist this threat, their independence would be jeopardized by the very fact that Congress, the creator and potential abolisher of the lower federal courts, had made the threat by passing such a bill. In B, it says, in 2 of the Jenner bill, the court was barred from reviewing executive action eliminating employees whose retention may impair the security of the United States government. If the bill had been passed, would the court have been barred from reviewing a dismissed employee's contention that his retention posed no substantial security risk? If not, how broad a restriction on Supreme Court review did this bill really impose? Consider Hart, The Power of Congress, to limit the jurisdiction of federal courts and exercise in dialectic. Harvard Law Review. He says the primary check on the Congress is the political check, the votes of the people. If Congress wants to frustrate the judicial check, or our constitutional tradition requires that it be made to say so unmistakably, so that the people will understand that the political check can operate. C. Suppose Congress sought to deprive the Supreme Court of appellate jurisdiction in any case brought by a Negro, in any case involving government aid to religion, involving denial of voting rights. What role do other constitutional provisions play in respect to the exceptions and regulations clause? And I'm sorry, my friends, but that's exactly how it was written. Like, what it's saying is, suppose Congress sought to deprive, an African American, and not a Negro. That's my apologies. Or in any case involving government aid to religion, involving denial of voting rights. What role do other constitutional provisions play in respect to the exceptions and regulations clause? It goes on to say D, for a collection of attempts to limit the court's jurisdiction, see Elliott Court Curbing Proposals in Congress. Notre Dame Law 567, 1958. For discussions of recent efforts to limit all federal court jurisdictions in all legislative reapportioning area, see McKay. Court, Congress, and Reapportionment, 1964. So essentially, what that all that goobly-glop was is basically saying that the Supreme Court has original jurisdiction when it comes to like the Constitution, when it comes to laws, when it comes to federal law, I should say. But when it comes to like matters of appellate jurisdiction, which would be things that are not federal, and things that are not, and we'll go into more of those as I go on. I'm going to continue. I'm starting section 2. Section 2 is quite long, so we're not going to get through all of section 2 today. Like I said, I've already been on this for 20 minutes, and I wanted to get through a little more so you can understand this a little bit better. I'm going to take a quick pause, though. Thank you for that pause. I need another one. I do apologize for that break there. I needed to use the restroom and get a drink of water because it's very mouth drying to speak all these words. Anyway, so I'm going to read a little bit more, and then it's pretty much going to be the end of the session because, like I said, this goes on for quite a while. But we're going to start with Section 2, Constitutional and Judicial Limitations. 1. Actions against state officials and the 11th Amendment. Charles Allen Wright, Federal Courts. In Ex Parte Young, 209 U.S. 123-28, Supreme Court 441-52, large edition 714, 1908. The Minnesota legislature, and this is where things get kind of interesting. I'm gonna stop. Hold up. I'm gonna take a break. I'm not taking a break. I'm just taking a step back to do like a explainer. So, not all of these cases are gonna be prolific. Some of these are gonna be like you're gonna think to yourself, "This is really what was brought before the Supreme Court," and this is one of them. It's an interesting case. There's a lot of interesting cases that end up before the Supreme Court. And this is one of them. So, the Minnesota legislature had passed a law reducing railroad rates. Okay. So, Minnesota had passed a law to reduce the rates of the railroad and providing very severe penalties for any railroad which failed to comply. Stockholders of 9 railroads brought suits in federal court to enjoin the companies of which they were stockholders from complying with the law. They alleged that the rates prescribed by the new law were unjust or unreasonable and confiscate. I said that 3 times. Confiscatory. Wow, that was a mouthful. And would deprive the companies. So basically, they can confiscate it, it's confiscatable. That's a word. I don't think that's a word. Uh, and would deprive the companies of their property without due process of law, contrary to the 14th Amendment, but that the penalties under the law were such that railroads, if not restrained, would comply with it. Among other defendants, they included Edward T. Young, the Attorney General of Minnesota, and prayed that he be restrained from seeking to enforce the law. This relief was given over Young's objection that the suit was in fact a suit against the state, to which the state had not consented, and thus barred by the 11th Amendment. And it goes on to say the Supreme Court did not write on a clean slate in deciding Young's case. In 1793, in an unpopular decision of Grissom versus Georgia, it had held that the Constitution permitted a citizen of one state to sue another state in federal court, though the state had not consented to such suit. The 11th Amendment was ratified 5 years later to take away the judicial power of the federal courts in such cases, and though in terms it does not so provide, it was construed as barring suits against a state without its consent, even where, as in Young's case, the suit was brought by a citizen of the state, and the basis of the jurisdiction was a claim under federal law. In an early decision, Chief Justice Marshall had construed the amendment as barring suit only where the state was formally a party of record. But the principle embodied in the 11th Amendment was too vital to be restrained by such formalism, and Marshall himself later construed the amendment as applying to a suit against the governor of a state where he was being sued in his official capacity. So, like governor, right? Like the governor of Illinois, or the governor of California, or the governor of Florida, any state, really. Blah, 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 blah. Let's see. Strain, blah, blah, blah. Over the next half century, the decisions were varying and uncertain. The court undertook to rationalize them and establish a rule on the subject. In 1887, in the case Inri Ayers, the decision there was that the suit against a state officer was not barred where his action aside from any official authority claimed as its jurisdiction was a wrong simply as an individual act, such as a trespass, but that if the act of the officer did not constitute an individual wrong and was something which only the state through its officers could do, the suit was in substance a suit against the state. The case would seem to be decisive of the Young litigation. Only a state can violate the 14th Amendment. Only a state can compel railroads to charge particular rates. Indeed, in Ayer's case, the relief unsuccessfully sought was an injunction restraining state attorneys from bringing suits under supposedly unconstitutional statute. The law was clouded between 1887 and 1908, when Young's case came to the court, by decisions which, in dicta at least, suggested that the commencement of a suit to enforce an unconstitutional statute could be considered an actionable wrong similar to a trespass. Against this erratic background, the court held that the injunction against Young was proper. Justice Peckham for the court announced the rule, which has since been repeatedly followed. Quote, the use of the name of the state to enforce an unconstitutional act to the injury of the complainant is a proceeding without the authority of and one which does not affect the state in its sovereign and governmental capacity. It is simply an illegal act upon the part of the state official. If the act which the state attorney general seeks to enforce to be a violation of the federal constitution, the officer in proceeding under such enactment comes into conflict with the superior authority of this Constitution, and he is in that case stripped of his official or representative character, and is subject in his person to the consequences of his individual conduct. Only the first Justice Harlan dissented. In a lengthy opinion, he argued, quote, the suit was, and to the defendant Young, one against him as, and only because he was Attorney General of Minnesota, no relief was sought against him individually, but only in his capacity as Attorney General. And the manifest, indeed, the avowed and admitted object of seeking such a relief was to tie the hands of the state, so that it could not in any manner or be any mode of proceeding in its own courts test the validity of the statutes and orders in question. It would therefore seem clear that within the true meaning of the 11th Amendment, the suit brought in the federal court was one in legal effect against the state. There is no doubt that the reality is, as Justice Harlan stated it, the fiction has its own illogic. The 14th Amendment runs only to the states. In order to have a right to relief under the amendment, the plaintiff must be able to show the state action is involved in the denial of the rights. It might have been possible to hold that the 14th Amendment qualified the immunity from suit granted states by the 11th Amendment, but the court did not so hold. Instead, it created the anomaly that enforcement of Minnesota statute is state action for purposes of the 14th Amendment, but merely the individual wrong of Edward T. Young for purposes of the 11th Amendment. Seems to hold that an action unauthorized by state law could not be state action for purposes of the 14th Amendment. The decision has never been specifically overruled, but was settled 5 years later after Ex parte Young by state officer claiming to act under authority of the state can be enjoined, even if the state has not authorized such action. The effect of Ex parte Young is to bring within the scope of federal judicial review actions which might otherwise escape such review. If Ex parte Young had been decided the other way, there would have been no practicable means for the railroads to obtain a court determination of the new rates Minnesota wanted them to charge. The state could, of course, consent to suit, either in its own courts or in the federal court, simply as a matter of grace. But even today, most states would have not done so. The railroads could have refused to obey the new law, and has asserted in its unconstitutionality as a defense to an action against them for its enforcement. But the state might have chosen to enforce the law by the criminal sanctions it supplied. And these were so severe that the railroads could not risk the possibility that they might lose and have to pay crushing fines. In such situations as where a state has failed to desegregate its schools, affirmative action is required of the state to fulfill its constitutional obligations, and there would not be even the possibility of raising the constitutional issue defensively. The decision was greeted with harsh criticism for years thereafter. For half a century, Congress and the court have vied in placing restrictions on the doctrine there announced. Notes and questions. Restrictions on Ex parte Young. Exhaustion of administrative remedies. In the same year that Young was decided, the court somewhat limited the power of a single federal district judge to enjoin the enforcement of state statutes by holding that, as a matter of comity and equitable discretion rather than as a matter of federal jurisdiction, a federal injunction should not issue until the allegedly aggrieved party has exhausted all adequate state administrative remedies. And it goes on to say Prentice v. Go look at Prentice v. Atlantis Coastline Co. And McNeese versus Board of Education. B. Three judge courts. In response to Young, Congress, beginning in 1910, enacted statutes providing that no federal injunction restraining a state officer from enforcing a state statute or administrative order on grounds of unconstitutionality shall be issued except by a court of three judges, at least one of whom is a circuit judge, with direct appeal to the Supreme Court. Case or controversy, Part 2. And it goes on, and then after that's established, it goes on to talk about advisory opinions. And so advisory opinions. Now I'll just I'll just read. Yeah, it's just better that way. I think it's better that way. Muskrat versus the United States. In 1902, Congress made a final allotment of lands to certain Cherokee Indians. Ooh. To my Cherokee brethren. To anyone that loves their Cherokee or loves the natives, this is for you. In 1902, Congress made a final allotment of lands to certain Cherokee Indians. Subsequent legislation increased the number of allottees and imposed various restrictions. Congress enacted a statute authorizing 4 named allottees under the 1902 Act to bring suits against the United States in the Court of Claims with appeal to the Supreme Court. Quote, on their own behalf and on behalf of all other Cherokee citizens, end quote, who were allottees under the 1902 Act, to determine the validity of any acts of Congress passed since the said act. For the speedy disposition of the questions involved, such suits were to be given preference by the courts, and attorneys' fees were to be paid out of tribal funds held by the government if the subsequent legislature were to be held invalid. Suits were instituted, and the Court of Claims sustained the validity of the subsequent legislation. The court per day, J, held that the jurisdiction conferred was not within the power of Congress, having in view the limitations of the judicial power as established by the Constitution, because the judicial power is limited to cases and controversies. Article 3 does not extend the judicial power to every violation of the Constitution which may possibly take place. By cases and controversies are intended the claims of litigants brought before the courts for termination by such regular proceedings as are established by law or custom for the protection or enforcement of rights, or the prevention, redress, or punishment of the wrongs. The term implies the existence of present or possible adverse parties, whose contentions are submitted to the court of adjudication. The court pointed out that as early as 1792, an act of Congress authorized federal courts to decide certain pension claims against the government, subject to revision by the Secretary of War. In Hayburn's case, 2-409, the court held that such duties were beyond the judicial power. By the Constitution, neither the Secretary at War nor any other executive or officer nor even the legislature are authorized to sit as a court of errors on the judicial acts or opinions of this court. In 1793, the court, in response to a request by President Washington and Secretary of State Jefferson, declined to offer its advice on the construction of treaties, laws of nations, and the laws of the land, which the Secretary said, "We often present it under circumstances which do not give a cognizance of them to the tribunals of the country." The act in Muskrat was found to be nothing more than an attempt to provide for a judicial determination, final in this court, of the constitutional validity of an act of Congress. It is true in the United States is made a defendant to this action, but it is no interest adverse to the claimants. The object is not to assert a property right as against the government, or to demand compensation for alleged wrongs because of action upon its part. The judgment will not conclude private parties when actual litigation brings to the court the question of the constitutionality of such legislation. In a legal sense, the judgment could not be executed, and amounts in fact to no more than an expression of opinion upon the validity of the 1902 Act. If such actions are here attempted, are sustained, the result will be that this court, instead of keeping within the limits of judicial power and deciding cases or controversies arising between opposing parties, as the Constitution intended it should, will be required to give opinions in the nature of advice concerning legislative action, a function never conferred upon it by the Constitution. Let that sit for a while. So that's what advisory opinion. So that basically, like, the president can't go to the court and ask it for advice. Does that make sense? I hope that makes sense. We've got a notes and questions section, and that's where we're going to end it, because then it goes into mootness and conclusiveness, and standingness and ripeness, and that's other stuff that the courts have to handle. So now on page 37, section 2, chapter 2. My mouth is dry. Give me a moment. The pros and cons of advisory opinions. Do you agree with the well-established principle that bars the court from advising the Congress on the constitutionality of legislation? Consider note advisory opinions in the Constitution. Consider the following. And this is in a Harvard Law Review. Quote, before it is successfully challenged, an unconstitutional statute may discourage legitimate activity, or conversely, it may encourage reliance, which, when the statute is invalidated, will prove to have been ill-founded, thus causing injury to those who have based action upon it. Further, there is frequently an unnecessary expenditure of time and money when the state enacts a statute, invalidates it in lengthy judicial proceedings, and subsequently must enact new legislation. This waste would seem particularly great when the government sets up elaborate machinery to implement a statute later held unconstitutional. So, like what it's saying there is, I mean, if they can't give advice, right? So the Supreme Court cannot give advice to the legislator when they're writing their laws. So the legislator they have to know the Constitution. They can't confer with the Supreme Court, which is the knower of the law, right? They know the law. The judges know the law. They interpret the law. That's what judges do. Good judges, I should say. That's what good judges do. And what it's saying here is, well, why can't they do advisory opinions? Wouldn't it make more sense to do so? Because it's quite expensive for, Congress to convene and to agree upon a law or a rule, and then just for the Supreme Court to strike it down, for them to have to pass a new law? It goes on to say B. Consider the comment from another law review. Quote, the advisory opinion, it is said, by Frankfurter, a note on advisory opinions, Harvard Law Review 2002, or 1002, 1924, would distort the entire focus of the judicial function in that it would require the court to express its judgment on abortive issues without the benefit of all the relevant facts, which in crucial constitutional questions are the very heart of the case. In addition, the operation of the device would debilitate the creative responsibility of the legislature in that it would tend to induce reliance upon the judiciary, depriving the former of submitting its convictions to the test of trial and error, and of accumulating new facts for the vindication of its judgment, which a priori may run counter to settled legal principles. I, or 1, as to the facts argument, might this be cured by having Congress present present the court with the specific set of facts, real or assumed, or by having the court confine its opinion to the statute's application to what it considers the most common set of facts intended to be discovered? 2. As to the responsibility of legislature argument, might this be cured by limiting the advisory opinion to statutes fully considered and already passed by Congress? Is there any answer to the point that cumulative experience of a statute's operation may shed great light on its constitutionality? If not, is this point sufficient to sustain the present advisory opinion practice? C. Is the opposition to advisory opinions justified by the fact that only when the experienced judge has had the benefit of intelligence and vigorous advocacy on both sides can he feel fully confident of his decision? Could the court, before rendering an advisory opinion, invite the submission of briefs and presentation of argument by interested parties on both sides of the question? Quote, argument in advisory proceedings might in some situations provide more assistance to the court than would argument in a normal adversary proceeding. Representation of diversified interests might provide the justices with a more realistic perspective on the statute that representation of only two parties, and unlike ordinary litigation where the prosecutor or plaintiff may be able to select an opponent with little interest in the proceeding or one who is particularly culpable, the parties seeking to appear will generally be strong antagonists. See also Trial by Combat and the New Deal, 1934. D. Consider note. Judicial determinations in non-adversary proceedings. The requirement that a specific injury have been suffered, or that the danger of such injury be substantial, probably has its basis, at least partially, in the belief that the respect in which the courts are held varies with the restraint exercised in deciding only the most critical questions. Is this belief founded on the premise that the court's ability to preserve constitutional values is limited and should be reserved for situations in which it is absolutely necessary? If so, may occasions for some advisory opinions present such a necessity? Or should the enactments of popular elected representatives be invalidated by a court of lifetime appointees only when injury is imminent? even when the popularly elected representatives request the court's advice, even when they believe that withholding of such advice may produce very grave injuries? Personally, I think that they should stay out of advisory opinions. I agree. I agree. But that's my opinion. Everybody's got it. This is America. It's the beauty of it. And that is the end of episode 3. Thank you for tuning in.